40705. Is it CEATS or CEATS? CEATS Inc. versus TicketNetwork Inc. and Ticket Software LLC, consolidated with 2022-40028. CEATS Inc. versus TicketNetwork Inc. Ticket Software LLC versus Milford Skane, Brian Billet, and Sonia McAuliffe. You may proceed.
Good afternoon, and may it please the court. My name is Brian Leske. I represent Appellant CEATS in this matter. These consolidated appeals involve the imposition of sanctions in two orders under Federal Rule of Procedure 37B. Given the court's directive regarding appellate jurisdiction, I think it's probably a pretty good place to start. We believe that this court has appellate jurisdiction to hear this appeal for two reasons. This case arises in a particularly peculiar posture, but it is different than the Zenith case and the other cases that have found that the appeal would reside with the Federal Circuit. In 2017, TicketNetwork moved under Rule 41A2 to voluntarily dismiss its complaint, which the court granted. That's in the record at 304 and 311. And this court in Williams recognized that Rule 41 can be used to dismiss individual defendants, but it can't be used to dismiss individual claims. It conflicts with the plain language of the rule, which talks about dismissals of actions, not of claims, something this court has recognized for a long time. Now, when TicketNetwork moved under Rule 41A2 to voluntarily dismiss its complaint, that ended the action. There was no claims, there was no cause of action, there was no controversy with CEATS, leaving the only operative jurisdictional basis, CEATS counterclaim, state law counterclaim for breach of the licensing agreement, which arose under diversity of citizenship. So if you apply the rule that the path of appeal is the path, is based on the jurisdiction of the district court, this court does have jurisdiction to hear this appeal.
I'm teaching civil procedure this semester, and this sounds like a final exam.
It very much so. Unfortunately, I think this one might be a case of first impression and last impression, because I don't know how many cases arise in this unique posture. But there's another basis for jurisdiction, for appellate jurisdiction of this court. Should this court believe that an individualized assessment of the claims be required, which, as I said, we don't believe it does. The TicketNetwork's complaint, in the first paragraph, shows it as three different claims. The first claim is a claim arising under the licensing agreement, seeking to challenge the royalties that CEATS was entitled to. The other two claims are classic patent claims involving non-infringement and unenforceability. When TicketNetwork went to dismiss its complaint, it turns out that one of the two patent claims were dismissed without prejudice, which means they don't have a legacy of patent law associated with them under the cases under Zenith. And the other case was not a patent case. That case arose under the licensing agreement. And the Supreme...
So there's no live patent claim no matter how you slice it?
No matter how you slice it, and there's no legacy of it either, because Judge Gilstrap appeared to believe, perhaps in the first sentence of the memorandum decisions that are under appeal right now, that this arose under the patent laws, citing the original complaint. And all the case law finds that you don't look to the complaint as filed to figure out whether it arises under the patent laws or not. You look farther down the chain if there were some event that changed the action in some way. And the Zitronix case of this circuit, and the Federal Circuit as well as the gun case, and all interpreting Christensen, make clear that the count one in the complaint, the one that was dismissed with prejudice, doesn't arise under, it doesn't pose a substantial issue of federal law. There were other claims and other legal theories espoused by TicketNetwork, and the rule seems to be pretty clearly that if the claim is dependent on patent law, it goes to the Federal Circuit. If it's not so dependent, then it stays with the regional courts. And honestly, Your Honor, this makes good pragmatic sense and public policy sense. This case, for example, has no patent law issue. Supervisory powers are best exercised by the regional courts, and it's...
Except that you're saying your ability to sue under the patent is enjoined.
I'm afraid I don't understand the question, Judge Haynes.
Okay, I thought you're challenging the district court's sanction.
The sanctions order...
Sanction keeps you from being able to sue
There-
over the patent.
It actually is even broader than that. It doesn't allow you to sue at all.
Okay, but part of what you would sue over is the patent, right?
No, our challenge to the underlying agreement itself is a challenge to the litigation ban that prevents both a licensing claim as well as suing, yes, for any other reason. But that doesn't mean under the Supreme Court's decision.
But it's not like you don't have a patent, right?
There are patents.
Okay, and that's been part of the arguments that you've had with each other over the years.
Yes, but
And now you're enjoined from suing over that.
yes, but it doesn't turn on the disposition of the patent. The litigation that we're here, the appeal right now, doesn't have anything to do
No
with
patent's going to be validated or
invalidated.
by the result of whether or not you can bring any claims against in the future.
In this appeal, yes, there's absolutely there's going to be no adjudication at all of any patent-related issue beyond the sanction.
This moment, but doesn't it prevent, if they then take your patent and start selling it to other people and you're enjoined, that has an impact, doesn't it?
That conceivably could have an impact.
Yeah, so that is part of this case. You're saying that they went way too far, the district court went way too far in what they enjoined you from, what it enjoined you from.
Yeah, that is our argument,
Okay.
but it doesn't.
But until
it
someone
doesn't-
tried to validate or invalidate the patent, even that case wouldn't be in the patent court. If it was just there bringing a case
that would belong.
that would be about what the order said and whether they were doing something beyond the order. It wouldn't be about the validity of a patent.
Yeah, any.
The subsequent hypo is not about a patent either,
That's right.
the validity of a patent.
That's right. We're here challenging a very different aspect. The court.
Why don't you get to the
To the merits, yeah.
case? We do reach them.
Yes, very, very good, Your Honor. The district court here erred and abused, the district court lacked the authority and its discretion to issue a litigation-ending sanction, an injunction that precluded CEATS from suing TicketNetwork for a period of 30 months. For the past 60 years, beginning in the Mitchell case and more recently in Cruz versus Maverick County, this court has insisted upon willful conduct or bad faith accompanied by contumacious conduct. And that's a deliberate, purposeful intent to evade a court order. And that is not present here under the record. And TicketNetwork's first...
Okay, but most cases involving litigation ending actually are ending the litigation. We, remove the answer, the this, the that. The problem that here to me makes this a difficult case is the litigation kind of had already ended. And then we're in this bucket where your people, got confidential information they weren't supposed to get and so on and so forth. So where does that put us in this world where typically litigation ending is ending litigation that's here right now, as opposed to the potential for the future that you've just finished arguing with me over, we're not bringing anything.
Oh, yeah. Under the circuit's precedent, the sanction that's issued by the district court here is unquestionably litigation ending, and let me tell you why. At the time of the disclosure, the trial was over, CEATS had prevailed, the jury had looked at the licensing agreement, had looked at the definition of subject functionality in it, had looked at TicketNetwork conduct, and found that there was a breach of contract and awarded royalties to CEATS. At that point, what was left, the jury verdict, though, however, in the trial, didn't extend to all the claims that CEATS had against TicketNetwork. Those were going to be brought separately. So what was left, it's actually claims after 2016, and the licensing agreement didn't end until 2019. So what was left for CEATS was to go ahead and sue TicketNetwork under the licensing agreement for all those claims and damages applying the jury verdict that was already there under preclusion principles and otherwise. And what the district court sanction here did was take that away. This circuit looks at the practical effect of the sanction in order to determine whether it's litigation ending. And it also looks to see whether the statute of limitations might bar the claim that would be brought in the future.
What's your best case for the proposition that this is litigation ending in a case where litigation's kind of already ended?
Well, if you
You're only talking about future litigation.
Well, if you look at Pond and Batson, they look at the practical impact, and they look to see whether a statute of limitations might affect the future claims. In the claims that are dismissed with prejudice, with the claims that are dismissed and then have to be refiled with the argument being that they might be barred by the statute of limitations, that's future litigation also. They may have ended that claim there, but the court is also looking ahead and seeing whether the claim that the plaintiff is going to bring in the future is going to be affected by the statute of limitations. And if you're not able to bring that claim, then the sanction, by definition, is litigation ending. It may be starting litigation before it started, but it certainly is.
Prejudice that really is with prejudice, those cases, that's what you're talking about?
Yeah, I mean, the future ability of those plaintiffs will be impaired by the statute of limitations. Obviously, the court doesn't make a finding that they will be barred because that would be an advisory, opinion. But if a case is going to be affected by if the sanction is going to affect the filing of a case afterwards, it's litigation ending in a heightened standard.
Cases where the district court dismissed without prejudice, but because it's after the statute of limitations, it's really actually
with prejudice. That's right, and the court uses
now, let's assume, arguendo, y'all did wrong. What is the sanction that the district court should have given?
Well, in this case, there was a litigation ban component to the injunction. There was also a licensing bar component, which did two things. It precluded CEATS from engaging in any licensing activities. Like the litigation bar, we think that's too broad for the same reasons. For a company cannot be engaged in any licensing activities is akin to a litigation bar. What was appropriate, and CEATS believes was appropriate, was to issue an injunction saying that any person at CEATS who viewed the confidential information is precluded, consistent with the licensing bar that was already in the place, from engaging in licensing activities for the period of 30 months, but not to apply it to CEATS as a whole. CEATS also, I have to point out, that in the course of this proceedings has spent hundreds of thousands of dollars out of pocket on the forensic examiner and everything else, so they've already incurred out-of-pocket costs, in addition to all their attorney's fees. So while we believe that, and the rule provides for a modest or a reasonable award of attorney's fees, it can't be to the magnitude of $500,000 or more, which is what Judge Gilstrap ordered based on the conduct that was before him. So we don't dispute that some sanction, some less onerous sanction is warranted, just not the outright prohibition of litigation by CEATS against TicketNetwork.
Your time is up, but this is very
goodness.
helpful. So I'm going to ask that we give 3 minutes to you and 3 minutes to TicketNetwork. And I don't know if the other person needs time, but we'll wait and see. But each side will have time.
Okay.
Additional 3 minutes.
Right now, excellent. Thank you, Your Honor.
Because I have a couple of questions. If we were to agree with you, assume arguendo, and this is not foreshadowing, that the district court used the wrong standard for bad faith, we remand on that and let the district court use the correct standard?
So our argument is actually threefold for a challenge to the underlying order. The first we have in our brief is a clear error challenge to its finding, to the judge's finding that Mr. Skane's request for non-confidential information was reckless. That's reviewed under a clearly erroneous standard. Our next argument is even if it's reckless, that the type of conduct that we're talking about doesn't rise to the level of contumacious conduct, which is a factual challenge under an abuse of discretion standard. And even if it satisfies that, there's an additional requirement that you find bad faith or willfulness, and we have a legal argument that's reviewed de novo that states that recklessness, recklessly disobeying a protective order doesn't rise to that.
Right, if
In the-
we
yes.
agreed with that argument and said, no, bad faith in this context requires something more, then we would send it to see back to the district court.
Yeah, I don't think you can in this case because the district court already made findings that
Right,
it was
but it-
reckless and not anything more.
But no, but it didn't. Did it say it was reckless and nothing more, or it just said it was reckless and reckless is enough?
It said reckless, and reckless is a more. This court has been very careful about sending these type of cases
What's
back.
your best case that we can't send this back for the correct determination?
It's actually cited in our brief in the remand section of our.
And you can't think of it right
And
now?
I can't think of it right now off the top of my head.
And the third party's part is going to be by Mr. England? Is that
Mr. Englander is going to address the claims of the individual appellants. And then we also have the challenge to the attorney's fee award, and we've made several discrete arguments in our brief.
So if we agree with you on that, what do? We do send that back.
Yeah, our argument is that if you modify the sanction order, then the attorney's fee order has to go back for reassessment and recalculation.
The problem to me about the hourly rate is, granted, I haven't been an actual practicing attorney for close to 15 years, but my memory is it varies widely, even across people of the same year. So if I went to law school with, X, my hourly rate might be 3 times X or with 1/3 X. That's just kind of how that works. So how can we say, oh, no, you have to find the same hourly rate?
Yeah, well, we're not arguing you have to find the same hourly rate. We're saying the court didn't explain the basis for its decision when there were other hourly rates already accepted in the case. But we also make a specific challenge to the associate, Mr. Colvin, who had the same hourly rate as the partner on the case. And that doesn't seem, and without any explanation by the district court. And that alone seems like a clearly erroneous finding because the court didn't, and nor did the court provide any explanation for it. So I see my time is up.
Okay. Thank you.
Thank you. May it please the court. I'm Brian England on behalf of the individual defendants. And actually reference right to your law school class on civil procedure. One of the first things that we learn is that due process requires that you can't come in a courtroom as a witness and leave as a convicted defendant. But that's exactly what happened here. These individual defendants had no notice whatsoever that they were being targeted for specific sanctions until the court had already found that they were guilty of a violation. And then they were allowed 7 pages of briefing on what the amount should be. The district court, in its opinion, actually derisively mentions this and says the individual defendants raised the due process concerns for the first time in challenging the amount or determining the amount that should be done, without pointing out or without any irony that that was the first brief they were allowed to file. They had given no notice prior to that time that they were being targeted to those individual sanctions, and that alone compels a reversal of this process. Moreover,
are your clients challenging application of the litigation and licensing bar to them or only the imposition of attorney fees?
Good question. We have joined in the CEATS appeal, but for purposes of our argument today, we're focused on the monetary sanctions. Dr. Willett unfortunately passed away last summer, so he will not be subject to that bar. And it's practically speaking, it's only the monetary sanctions that matter to the individual defendants. And this actually has very real-world implications, however, because the district court applied Rule 37 against a non-party. And that's not an esoteric thing because now another district court in the United States has used this as a but-see site. It makes clear that there is no authority whatsoever to extend Rule 37 against a non-party, but see this case where the district court found that signers to a protective order may be subject to sanctions under Rule 37. That's improper. The district court can't create a whole new exception to Rule 37 on this record. That's another and the reason that matters is the standard for when you can apply sanctions under Rule 37 versus the court's inherent authority are very different, dramatically different standards, as Mr. Leske pointed out to you. There has to be a finding of bad faith, intentional conduct on behalf of these individual defendants in order to sanction them under the court's inherent authority. There would also have to be a recognition or an opportunity to investigate lesser sanctions and whether those could be applied. And this court's own jurisprudence requires the court to take into account the ability to pay.
You called them individual defendants. Are they was a amended complaint filed or something where they're named as a defendant, or how are they defendants?
Perfectly good, and they are not. They are individuals who are subject to the protective order. They are not parties. Yeah, non-parties. That's a much better phrase.
I may have missed this. You said that, I'm sorry to hear that Mr. Willett passed away. Was his estate added to this case?
No, we are actually in the process in the state of California of trying to get that done, and we were not able to get it done before the court scheduled the oral argument. Dr. Willett passed away in June of last year, and we don't have authority yet to act on behalf of the estate.
So where does that put us?
Well, Dr. Willett paid part of the sanctions award, and so if we get a reversal of that, it would go back to his estate, and his estate will then act if there is further proceedings down below.
Do we have to wait?
No, I don't believe so. I believe that he challenged, we challenged the finding before that happened, and the appeal is properly before you to determine that the district court exceeded its authority. But on the last question that you asked, Mr. Leske, very briefly, on this record, you actually don't have to remand this to the district court with respect to the individual non-parties. There's no basis whatsoever to hold them liable.
It's not the 450 versus 300 per hour, it's zero.
As to them, as that, there's no due process basis to impose any sanctions against these individual defendants. And I see that my time.
I think we have your argument.
Thank you very much.
May it please the court, I'm John Thornburgh for TicketNetwork. I will start where Your Honor started with the other side, which is we agree with them that this court has proper jurisdiction. I would just add that the case that the court cited in its notice, Zenith, says further down that where the patent claims were dismissed without prejudice, the Federal Circuit doesn't view the case as arising.
And would our circuit view it as arising? You know, we've got that other case that starts with an X that we go back and forth, and then one subsequent to that we've gone back and forth.
And I think that involves the more complicated question that...
But this is not that complicated?
I don't think it's that complicated, because I think arising under is a very, very narrow standard. It doesn't mean that it affects patents or impacts patents. It means it arises under the patent law.
Okay. You talk about these non-parties who say, oh my goodness, we got a judgment against us. That seems shocking. So perhaps you could give it some context from your perspective.
Yes. So one of those three individuals is Mr. Milford Skane, the CEO of CEATS, that Judge Gilstrap found was CEATS, and who attended all the hearings and was very aware of how important this information was. So I think...
Have claims against him is somehow that the corporation formalities weren't followed and he's really the same as the corporation, and therefore was that pleaded and decided and all of that?
Well, Your Honor, we're not the plaintiff, so we have not filed any claims against anyone.
Or in defenses? I mean, it just seems very odd. You need to help.
Okay, so this is purely a sanction for violation of a protective order. It's not a claim or a counterclaim. It is because these individuals, well, Mr. Skane is in charge of CEATS, or was at the time. The two individuals are experts who signed on to the protective order, which says in it that you can be personally liable for violating it.
Right, but don't you have to find a suit against them and find them liable for violating it?
Not in these sanctions cases. This is a discovery sanction. It's not a litigation. These people egregiously violated the protective order.
How did the court make them aware that they were personally going to be, when they show up to go on the witness stand?
Right.
Does the court read them their Fifth Amendment rights or something? I mean, how do they know that they're personally on the hook for anything that's going to happen?
So, three ways, Your Honor. The first is the protective order that they signed says it, that they can be personally liable. Second, when they violated the protective order and Judge Gilstrap issued an order to show cause, he directed it against the party and any individuals, and this is quoted in our brief, who were responsible for the conduct. And so they were on notice that he was aiming at individuals.
They were personally served as individuals with the show cause.
They were not personally served. They were not. But they did receive actual notice because they showed up. They came to the hearing and testified. And they knew he was looking at the individuals responsible for violating his orders. But then I would say the clearest example is
How did they know that? You said they knew it.
he wrote it in his order. He said individuals responsible.
But he didn't serve it on them.
He did not, but they received it.
As witnesses doesn't mean they know what all the documents in the case look like, right?
That's a possibility. So the third way that they definitely got notice was before he ordered, they are only appealing the money, right? The monetary sanctions. And so his first sanctions order imposes the injunction, finds the violation. He then did give them an opportunity to appear and file a brief on the monetary
But they've
sanctions.
already been found liable, and now it's just a damages case. But being found liable, I want to say I didn't run the red light before I have to pay for all of the damages to the other side.
And that's what they put in their brief. They were free to argue zero, that they argued due process to him, they argued zero, that they were not responsible. And so, but I should step back a moment and say that, by far the most important thing to our side is the injunction, because it protects against the misuse of this information. And, our view is that TicketNetwork should be made whole for having to undergo this ordeal, this very expensive investigation that was made more expensive by the misconduct of destroying evidence and hiding evidence. But, CEATS has paid the vast bulk of the sanction. They paid 400 out of 500. Dr. Willett paid the remaining 100. So from our perspective, the most important thing is that CEATS gets that TicketNetwork gets compensated, and CEATS has stepped up and paid. And I think that if it's going to try to collect from the individuals, that should be a fight for another day. We're not going to take sides on that. But the important thing that should be affirmed is that CEATS is responsible for the conduct of its CEO, the conduct of its experts.
Okay, what's your response to the fact that the hourly rates were quite different than the district court found were proper hourly rates for these kinds of people? So
it's entirely possible that two different rates can both be reasonable, because I should apologize also, Your Honor. Are you asking about the difference in the rates between our rates versus the earlier part of the case, or the associate versus the partner? Okay. So when CEATS obtained attorney's fees, which is automatic under Texas law in a contract case, we didn't even oppose their rates. They said, these are our reasonable rates. We didn't even say they're not reasonable. And so that was accepted. But we attacked that award as greatly disproportionate to the verdict, but we didn't say the lawyers' rates were wrong. And so the judge approved their rates, but that doesn't mean those were the maximum possible rates that would be reasonable. It just means that those lower rates were not unreasonable. And so when he then was presented with the issue of, are our rates also reasonable? He reduced it. I mean, we asked for, I think, $700,000. He reduced it down to $500,000. And so he didn't just rubber stamp it. And that's how we got to the point where the associate and the partner ended up at the same rate. Fish and Richardson does not charge the same rate for those two lawyers, and that wasn't what the bill says. But Judge Gilstrap, in his experience with these individuals and the case, evaluated what would be a reasonable rate, and he reduced them both down to the point where it turned out to be the same. But he clearly put a lot of thought into it. He made a lot of detailed edits. So this was not a case of a district court just rubber stamping.
What do we do if we think that the standard for contumacious conduct is correct? Recklessness is not enough.
So to answer that question directly, I think the answer is remand. I would like a chance to argue for why that standard is correct or waived, but I think there's no question that if this court wants to set a new legal standard, and frankly, this is not an area of law where there's a whole lot of cases, but if you want to set a standard, then you should remand and ask the district court to make findings using that standard. Because I would note that Judge Gilstrap was careful. He didn't want to go out of his way to badmouth people, but he said, we told him that the standard was reckless disregard, and his fact finding is that these people acted with at least reckless disregard. He also found that they were aware of the risk. So I think if you tell him that he needs to find intentional disregard, I heard that from the argument earlier this morning, or earlier in the afternoon, if that's some other standard, but that standard was never mentioned in our case, I think he'd probably find it. But you should remand to give him that chance, because he did say at least. And there's nothing due process wrong with doing that kind of remand. To answer Your Honor's question about which case they cite, they cite a Tollett case when they say it violates due process to remand for fact findings under a new legal standard. And that's just not right. I mean, every time an appellate court changes the legal standard or clarifies the legal standard and orders a new trial, you remand for new fact findings.
You say at least this, it doesn't mean that you wouldn't find more than that.
Exactly right, Your Honor.
If you don't need to find more than that, you're usually careful to not go out of your way to find things that you don't need to find.
Exactly right, especially in a context like this.
Can you help us, though, why this is the correct standard?
Yes.
It seems lower than what, perhaps. So can you help us?
Yes, first of all, I would note that it's reckless disregard and not just recklessness, and I think that's a difference. I mean, like in some states, there's like statutory recklessness. If you're driving 100 miles an hour, that's automatically reckless, and that may not be subjective. Whereas, if you drive 30 miles an hour through a crowded intersection, you may not intend to kill anyone. You may not even know who those people are, but that is subjectively reckless disregard for human life, and I think that's the idea of reckless disregard that Judge Gilstrap had in mind. I think he perceived defiance of his authority, and the Moore cite that we gave to him twice, we gave it both in the original show cause brief, and then we put it in our final brief after the forensic investigation. We put it in there twice, and the other side never said anything about that Moore's definition to him, and so he just copied it into his order. So I think they waived it. They now argue that it's inconsistent with Pressy. They didn't argue that to him. They cited the Pressy case and said you got to find bad faith, but they didn't say that Pressy made any kind of holding that was different than Moore's, and I don't think it did. If you look at that case very carefully, it came out of Judge Hughes in Houston. He entered a very severe sanction against the city. $8 million default judgment without a written opinion. So he, unlike Judge Gilstrap, who spent a year developing a record and writing detailed findings of fact, he sanctioned the city, did not explain himself. And so this court was not reviewing, a very careful order like Judge Gilstrap did, where he based sanctions on a express finding of reckless disregard of the court's order. Instead, all Pressy has as a passing comment was, maybe this is at most recklessness. You should do an adverse inference rather than a default judgment. That's what the other side's basing their argument on, is that offhand comment. It was not a sanction based on reckless disregard that the court found wrong as a matter of law.
I'll tell you the part that I find the hardest here is, I don't know, if someone stole my iPad, they probably wouldn't walk into my office waving around the iPad. And so here, Skane thought he was getting unconfidential information and sends it to Ticket. And so if he's writing TicketNetwork, knowing that he's got the confidential stuff, why would he do that? I mean, he would use it if he's being wrongful and evil and bad. I'm not saying he was, but if he is, he would use it for secret stuff. He wouldn't go, here, knowing that he's not supposed to do that. So why doesn't that support the notion that it's really negligence?
So again, this is fact-finding that Judge Gilstrap made after looking these witnesses in the eyes, and he found that they were seeking out a version of our list that was not marked confidential. That's in the order. That they weren't looking for non-confidential. They were looking for a version that wasn't marked confidential. And he also found that they took advantage of it to get undue advantage in the settlement process. And so the way our client reacted to this, and the way Judge Gilstrap found, is we got this email with our clients attached to it, and they said, we want, $10 to $100 million, we know who your clients are, you better pay. That's how we perceived it as a ransom note. That it was a threat, that they were going to go harass our customers, and that this list was,
But if they know that this is the list we're going to be sanctioned on to send and try to get ransom, I guess I'm just struggling a little bit with that, how that makes sense.
I think it was, arrogance and misuse of our information. That this was sent, by their CEO, Mr. Skane, to our CEO, and he was demanding millions of dollars, attaching the list of the next victims if we don't pay up. And I agree that they had, the other side did make the other argument that it must be innocent if we revealed our misdeeds. Why wouldn't we hide that, right? And I think it was arrogant and aggressive, and that's what Judge Gilstrap found. That that's certainly you could argue those facts either way, but I don't think it's clearly erroneous, which is the standard, to draw the bad interpretation of those events.
And that copy didn't have the secret thing, so he's showing him he has a copy without the secret information.
That's right. It's not marked in the version that he sent.
So it could, yeah.
So he may be.
So he may be it may be innocent, but it also may be, and you're not going to be able to get me for having this because it doesn't even have the sticker on it or whatever. If he's keeping up so carefully.
Right. He's probably plausible deniability in his.
Yeah.
But he himself was very aware because he attended both of the hearings where we resisted very much giving this list over because we wanted to say, look, you can have your fight with us, but don't mess with our customers. And the magistrate judge was convinced to let them have our list. But Mr. Skane was in the audience, and he knew how very important it was, and the way they got the list was promising not to use it for licensing and litigation. And they themselves proposed the language of the licensing bar. And so I would say that this is another basis to affirm, besides waiver or besides the fact that we're right on the definition of bad faith, is that what we have here is really a modest extension of the agreed licensing bar. They're not here to appeal the original licensing bar, which lasts 12 months until the end of the litigation, including any appeals. So that licensing bar still has at least 12 more months to go. And 30 months from Judge Gilstrap's August 2021 order is going to end up being at about the same time. That was 18 months ago. So both licensing bars have about a 12-month life at this point. So the length is probably irrelevant. And then the fact that he extended it to the entire company rather than just a few individuals was very much justified. Not as a death penalty sanction, but just as a practical remedy, because none of the people who misused the information could rule out that they shared it with other people. We know that when Mr. Skane originally was caught, he said, well, I didn't share it with anybody else. But then the record revealed that he shared it with two of his colleagues, and then they said, well, those people, at least, they're not involved in licensing. But, I mean, CEATS is a non-practicing entity. Their whole business is suing people and licensing people. And so, and then they destroyed the evidence. They destroyed the emails. The forensic investigator said, I can't possibly conclude how far this information permeated throughout the company. And so on that factual record, it doesn't have to be a death penalty sanction to say, look, it's got to be the whole company. At this point, we don't know who has the information. And so the original licensing bar should basically reach the same result, that they can't possibly be allowed to use this information to go harass our customers. I think that Judge Gilstrap's finding, I'm going to quote one sentence because I think it really encapsulates what we're dealing with here. He wrote, CEATS and the involved individuals recklessly disregarded those procedures and attempted to obfuscate their misdeeds once caught. I mean, that's a lot of powerful language. He was restrained, but, misdeeds obfuscate. He did see this as contumacious behavior, that these people were defying his protective order, lying to his face under oath when he questioned them, destroying the evidence. You know, if they were innocent, the electronic record would support them, but instead they destroyed it. And so, you know, this is really as bad a behavior as he's probably seen, and so the sanctions are very much tailored to protecting us. It's not a case where we could have an adverse inference, right? That's often a lesser sanction. But he struggled and said there's no other lesser sanction than this injunction. And as far as the $500,000, yes, it's a lot of money, but it was mostly caused by the resistance to the investigation. And you know, at least CEATS should be responsible for that amount. I would also say, though, that neither CEATS nor the individuals briefed joint and several. We had put that in our proposed order. It was never challenged, just as the definition of bad faith was never challenged. So we think there are, you know, very important waiver issues on all the issues in this case. I have time left, but I'll pause unless your honors have any more questions.
I think we have your argument. Thank you.
Thank you.
Thank you. I'd like to mostly respond to the factual assertions that were made. Most of the points that my counsel has made is based on evidence that TicketNetwork submitted to Judge Gilstrap, not the judge's findings. If you review the sanctions order, Judge Gilstrap did not find that Mr. Skane lied under oath. Judge Gilstrap did not find that he intentionally deleted his emails. Judge Gilstrap did not find that he intentionally sent the spreadsheet over to TicketNetwork. Those are fine. Those are based on their argument to Judge Gilstrap that does not appear in his order. And he was very clear in one of his footnotes to say what his findings of facts were. And findings of facts are important. They provide the basis for this court to review a sanctions determination, particularly one that is so serious as the one here. And if this court were to accept a lot of the facts that my brethren here has endorsed, it would essentially be engaging in implicit fact-finding. And this court recently made clear that it should jettison that approach in favor of a basis of decision approach. And if you read Judge Gilstrap's sanctioned order, none of those things are in his record. And counsel can say, well, he wanted to treat them fairly, or he wanted to use kid gloves. That's not the way it works. Not the way it works for an appellate court to have to review a district court's findings.
Can you deal with the waiver issue, please, or what I might call forfeiture?
Yeah, they make a series of waiver arguments. Obviously, our challenge to the factual findings as to the conduct on contumacious conduct isn't waived. We all along said that the conduct that was at issue
No, but did you say that wasn't the right standard? And when they cited the Moore's federal practice with the standard, did you say, no, that's the wrong standard? Look at Wright and Miller here. It says the standard is this other thing.
Well, there's two things. This court in Cruz recently, Cruz versus Maverick County, makes clear that there's actually two components. There's the conduct. You have to look to see whether the conduct is contumacious. That's an abuse of discretion standard. That's just, does the evidence add up to something that's a deliberate violation of the court order? Then there's a legal argument, that is, does the conduct give rise to bad faith or willfulness? And those are two distinct arguments. So they're arguing that we waive the bad faith argument. Granted, they buried the legal standard of recklessness equals bad faith in one page of, or one sentence in 3 pages of legal argument. We argued that none of them were met. But even so, even if we didn't preserve the issue that recklessness doesn't equal bad faith, we unquestionably argued that the conduct at issue doesn't give rise to contumacious conduct.
What about joint and several? Did you waive or forfeit that?
Ticket networks didn't even mention joint and several in any of their briefing. The same thing, the only time it arises, anytime it appears, is in a sentence in a proposed order early in the litigation that Judge Gilstrap copied and pasted into the ultimate order. So they didn't brief it, and we didn't brief it either. But same thing, a factual standard applies there. We're not responsible for everyone. We were only responsible for Mr. Skane, and that's what Judge Gilstrap found. He found we were only responsible for our agent, Mr. Skane, and not the other individuals. So even under a fact-based challenge to join in several liability, holding us responsible for everything, it fails as a legal matter or a factual matter. Oh, and the two cases, I'm sorry, Your Honor, if I may. The case I couldn't remember was the Gillette case for the remand, that this court can take it on its own to decide what sanctions are appropriate, and that's SIDAG also versus smoked food. I apologize.
Thank you.
Sorry.
Argument, this case is submitted. Thank you.
Court to give testimony. They left hit with financially ruinous sanctions. There's exactly zero evidence in the record that the district court ever considered lesser sanctions. This court's jurisprudence requires that. He imposed joint and several liability against Ms. McCullough for over 10 times her annual salary. The case law is clear that for garden variety inadvertence, you can't use your inherent authority to issue financially ruinous sanctions. The one clearly erroneous finding that the court made was that Ms. McCullough had removed that confidentiality designation. That never happened. It was in a cover email in the fog of 14 months of litigation ending, and now she's asked to provide a non-confidential document. She thought she did. They came to court, they admitted to negligence, and they left defendants being hit joint and severally for sanctions 10 times or more of their annual income. That's not due process. That can't stand. Thank you.
Thank you. You didn't even use your whole minute.
2 seconds.
Thank you. This case is submitted.